Listen,
yeah.
Justice Mander, in the sentencing of Lauren Dickason earlier this year, made a number of, I thought, sympathetic remarks, it have to be said, as to the plight that Lauren Dickason found herself in prior to murdering children. The jury, and we've talked about it before, how can you get off on the basis of arguing insanity? And you said it's a very, very high bar, thank you very much. And you didn't poo-poo it, but you rightly discerned that the jury would come to the outcome that they did. At the hearing, at the sentencing, though, Justice Mander, as I said, made a relatively sympathetic, it has to be said, judgment as to the circumstances of Lauren Dickason. Do you think that's likely to be the comments that he made, the basis for the appeal, or alternatively, that the jury didn't understand the expert advice that was being provided to them before they came to their verdict, or both?
No, if the Crown was unhappy with that sentence, then it would be a Crown appeal against, and the Crown, of course, are entitled to appeal any decision, the same as a defence is. But again, I think we did cover this last time, is that Justice Mander could be sympathetic, could see that the defendant, Lauren Dickason, was suffering a mental health disorder, was suffering deep depression, but that the jury could also quite properly have found that, but not to the stage of insanity and not to the stage of infanticide. So there was a disorder, whereby a sympathetic approach was adopted and could be sustained, but it did not reach the level where an acquittal or that alternative decision of infanticide was available to the defendant. So it's really it's not incompatible that he had sympathy, that he understood from the medical evidence he heard, and I think both sides accepted there was a level of mental health involved here, and the debate came between the Crown saying, but not insanity, not infanticide. The defence said otherwise, but it did not prohibit Justice Mander from actually making the rulings he did for sentencing purposes.
The ones that are lodging this appeal to the Court of Appeal, not the Crown, on the basis of sentence. There are no indications yet as to what as I understand, Marie, as to what those grounds of appeal are. But I wondered if you could just speculate for a moment what they might be that would be successful. How does one go from a jury trial in which the jury are unanimous as to guilt to an appeal against the convictions to a Court of Appeal?
Well, I think there might be a misconception out there in the general public view is that an appeal is based simply on the fact that the outcome didn't go the way you wanted it, and so you can just ask for another trial. It just doesn't work that way at all. Yeah. What you have to establish is that, and you have to have grounds for this is what you've got to set out eventually, and eventually the appeal will be heard in the court, is basically that something went wrong. There are errors within the trial process that the party is saying amounts to what we call a miscarriage of justice. It's a pretty high bar, but that could come from a variety of grounds, and some of the more general grounds, when you look at, you might get someone come with you and say, look, you weren't the trial lawyer, but have a look at my file, tell me if I've got appeal grounds. So you look at the judge's directions, the judge's summing up, and see whether there was anything you say is wrong, whether you think there is insufficient evidence to have sustained the finding. That's a very hard one to get around, that particular one. You might be arguing that the prosecution, there was some sort of misconduct along those lines, but in these days, that's also a very rare one because we have lots of disclosure. We have access to the files. We don't fight over getting the files anymore that we used to a long time ago. So that's the sort of things that you look at, and you might also look at some pre-trial matters. So, say for example, you apply and say, I want to lead this evidence, or I think this evidence is inadmissible. I might, as a defence lawyer, say that shouldn't be led. A judge decides, yes, it is or it isn't, and you say that actually tainted the jury and made the verdict unsafe. So you have to find there was something unfair about how the way the trial took place, that there was a mistake, it was a legal mistake, and that on the evidence the verdict just can't be sustained. You might sometimes find outside the trial system that there's new evidence that's come to light that wasn't available when you were looking at the trial, something new. But you're really looking at procedural or legal errors, really, and say there are mistakes or misapplications of the law. But that is what you have to establish. So it's not just let's have another go. I didn't like the result. You really have to be able to sustain really specific errors of law that may have, or at risk, have occurred at the trial and may have affected the verdict. And it's a very different forum, a very different way of arguing. And you have to switch the way you act, in that forum than what you would do in a trial. They're two very different processes.
I understand what you're saying to me, but it would seem that getting to the Court of Appeal is the easy bit. You don't need leave to appeal to the Court of Appeal, do you?
Not the first step. Not when, say, for example, you might have district court, your first step's the High Court. If you're in the High Court, then your first step's the Court of Appeal. And that's the right. But what you still have to do, you give notice of appeal. The next stage that the Court of Appeal requires you to do is to provide points on appeal or grounds. So they then say, well, what are you going to argue? What do you say if you come to our court on appeal? What are your grounds? And at that point, the court can still nonetheless say, well, you haven't really made out the grounds here, and you don't actually get off the starting block. So the Court of Appeal, say, for example, can have a look initially and have a look at those grounds of appeal, and they may say, well, there's just nothing here, and we can't waste the court's time. There are no real sustainable grounds.
So will they make that decision?
It's not without challenge.
So will they make that decision prior to, or is it automatic that the Court of Appeal will convene, 3 judges, and that they will hear the appeal? Or do they look at the papers first and go, nah, we don't think this is justified?
It will still be a panel.
Yeah.
It will still be a panel of 3 judges, and they will look at your grounds, what you say are your grounds. They will also have a look at the trial evidence and summings up and stuff like that, and then they may rule, that there are insufficient grounds.
It's just that, as you know, there's a fair degree of public cynicism as to appeals from murder judgments in this country. And they seem, on the basis of at least media coverage, Marie, to be relatively common. And they also seem to be relatively unsuccessful. Are there fiscal incentives to appeal a judgment?